All right, everyone. Welcome to the webinar, Navigating HR Amid COVID-19, presented by the Temecula Chamber of Commerce. The first half of the webinar will consist of 2 presentations, and the second half will be a Q&A. Today's presenters are Jan Smith, the founder and president of Inland Management Group, and we have Shin, Associate Attorney for the Law Offices of Rosenstein and Associates. Before we begin today's webinar, we have a few Zoom etiquette guidelines to make this an effective meeting for all of us. The first one, all attendees have been muted. If you have a question, please enter it in the chat box or Q&A box. They are both located at the bottom of your Zoom screen. Number 2, you will only be able to see the presenters in their presentation. You can't see or hear you. And the third one is I will send out a follow-up email with a video copy of today's presentation, along with any links or documents discussed and the speaker's contact information. So now we're going to go ahead and begin. I'm going to start with Jan Smith. Please welcome Jan.
Hi, good afternoon, everybody. I'm glad to have this opportunity to talk with you today. And first, though, I'm hoping you're all well and your families and your businesses are doing okay. I applaud that you're being on the call today, either to learn some things to continue to maintain your business in these really much altered working conditions, or ready yourself to restart your business in the near future. So as just a brief introduction, my name is Jan Smith, and for those of you that I have not met, I live and work in the beautiful Temecula Valley. Been here for about 21 years, and my business, Inland Management Groups, works to support the hospitality and service industry for operations and human resources. So today I intend to share some current legislation that are both employee-centric and employer-centric. So I'll try to point out where the differences are, but mostly important information for you to know as business owners. So I'm going to start with getting my presentation up. So I think we're going to go ahead and share a screen here, if we can. Brooke, I'll need you to allow me to share my screen, if you could. Brooke, can you allow me to share a screen?
You should be able to.
Okay, sorry for the interruption to those on the call here. We tried this morning, it works, but we're trying it again now and we are unable to do that. So let's see if we can make that.
Okay, go ahead and try now.
Okay. Let's see. I don't know why that might not be working here. Any suggestions, Brooke? Doing exactly what we did this morning and it was working just fine.
Do you want to email me your presentation and I can bring it up?
Let's see if we can make that happen.
Thank you everyone for your patience.
See.
Okay. In the meantime, if anyone has any questions or comments or anything that you have about HR right now, please put them in the chat box or in the Q&A box.
Hey, Brooke, I've just tried to send that to you. Let's see if we're able to make that happen.
Okay.
I can check the chat box, I suppose, and see. Brooke, Samantha Dofo wants to know where we would find the mute. And I guess you've already replied that's muted. So it looks like that we're good there. So this is the world we're all living in. We are learning new systems. Zoom, we should all probably have some stock in Zoom, right? Because it's being used so widely and is just both a great tool when it works. So if you can just give us another moment here, we'll see if we can get this to work. If not, we'll go right ahead without it. Unfortunately, it'd be fortunately though, to have that would be helpful for you to see visually some of the things that we'll talk about today. Have you received?
Yes, but it wasn't saved as a PDF. I have a Mac or a PC. I don't have a Mac.
Oh my goodness. Okay, I think we're just going to have to go ahead then and go forward without this. I'll be happy to send this information out to Brooke and she can send it on to you. So we'll just kind of go without it. We'll try one more time and see. It just doesn't show up, Brooke. So it must be something in the system of allowing everyone else to see it, perhaps.
Okay.
Is there anything you can do on your end, or shall we just go ahead?
I can make you host. Okay, now try it now.
Yeah, it's just not there. Okay. All right. Well, some of this is very visual, so I'll just kind of improvise with the information I was going to give you. What is remarkable is that we have now what I consider an alphabet soup of COVID terms. We must have a good 8 or 9 new acronyms that are now existing law that never existed before the last 30 days. And this has caused both business owners and individuals like myself a lot of sleepless nights to learn these processes and what they mean for you, because they definitely mean something for each one of you as a business owner. So when you get the information that I sent Brooke, the slide set, you can maybe just go through that and see what some of these things look like. Maybe you've heard them and you don't know what they are. Things like CARES and FFCRA and PPP and PUA. I could just go on and on for another 8 or 9. That's what these state and federal new legislations look like in terms of acronyms. So I wanted to provide a kind of an overview of some of those that make most sense to you as a business owner. And the first one is what is considered the Family First Coronavirus Response Act. It's known as FFCRA. It includes a couple of things that are important for you to know for your employees. It's a government mandate that provides businesses with a viable plan to balance employee and organizational needs during the COVID pandemic. And these are going to be both employee and employer-centric. This particular one, employee and employer-centric legislation. So private employers with less than 500 employees and public employers of all sizes must provide paid leave to employees for certain COVID-19 related reasons. There are some exclusions for small businesses. So if you're under 50 employees and it could be an extreme hardship and some other reasons, you'd probably want to explore if you would be able to be excluded from this particular benefit. But it does benefit the employees that you that you have and you still employ. So any employee who is unable to work for reasons due to COVID-19, they are entitled to a paid sick leave for up to 2 weeks or 80 hours. This is for full and part-time employees, and it's at their regular rate of pay. A part-time employee can take this leave for the average amount of hours per day up to a 2-week period. And so you probably wanted to take a look and see what was scheduled, and if they were sick for a COVID-related incident, you would be giving them this paid sick leave through the FFCRA. So this is something you want to know, because if you continue to employ, once we kind of release people back into the workplace and the workplace opens up again, we may be seeing more incidents of the virus in the workplace. And so this may be a benefit that could be utilized if your employee is out of the regular 24 hours of sick pay offered by the state already. This is in addition to, and that can be very helpful for them. So the employee has to request this, though. So if they're out and it's, it's not something you would just put into payroll, you'd have to have them request this. They need to text or email you with their name and the date of which they would like to exercise taking this paid emergency leave, the reason for the leave, and a statement on why they're not able to work. And basically there are about 6 different opportunities of classification that would allow them to be able to take this type of paid leave. And unfortunately, I'm going to have to read these because you would have seen them on the screen. But one is that the employee is subject to a quarantine or an isolation order. And you could ask the employee to please include which entity that is that issued the order, but it's very clear it's going to be a state or federal order. Number 2 is that the employee has been advised to self-quarantine due to COVID concerns, and they need to give you at least the name of the provider that told them they should self-quarantine. Number 3 is that the employees can experiencing COVID-related symptoms and seeking medical diagnosis. And you can ask the employee, basically who was suggesting that they did quarantine themselves. And that's probably going to be the name of their medical provider. Now, we're not asking for a note from that. And in fact, there's 2 sides of the story here, if we should be even asking for notes or not. So right now we're just asking the name of the physician. And Jenny, at some point in your conversation, you might be able to expand on this from a legal perspective, if we really should be asking for the employee to get a doctor's note. Again, most of the people that I have contacted on this have suggested not, just getting the name of the physician or the healthcare provider. And then number 4 is that they may be caring for someone else. Maybe it's somebody in their household who has these symptoms or has been quarantined. And so you could ask the employee to provide the individual who they're caring for. And number 5 is taking care of a child who is out of school. We all know the schools are closed and they don't plan to reopen now until sometime next semester. Or their child care provider is no longer in business, and so now they're at home. They would also be able to qualify for the 10 days of emergency paid sick leave. And then number 6, which is a really kind of, it's like, let's just throw everything all in one basket here, is the employees experiencing any other substantially similar condition specified by the U.S. Department of Health and Human Services. Not even quite really sure how to describe that any further. It just looks like that kind of covers and any other reason. But you do have the opportunity to ask that employee how, or why the reason is that they're taking off. Now, I would suggest if you're going to do this, that you make sure you speak to your payroll provider to make sure that they are explaining how you're getting the credit for this, because this is credited back through your I believe, quarterly taxes. Again, this is a payroll question or a CPA question for you. But know that the money, those 10 days, are somewhat reimbursable to your company. You're paying them up front, but you're getting a credit on the other end. So there's the paid sick leave, and then there's the paid family medical leave. For employers that are over 50, they're already familiar with the Family Medical Leave Act. This is an expanded version, and it includes everyone, even employers under 50. And it provides for 10 weeks of paid family and medical leave. The employee must have been working for you for at least 30 days to receive that prior to asking for it. And it is more specific. It is intended to be used if they are caring for a child under the age of 18 because their school has been closed or their child provider has been closed. So they, under these two systems, they can apply for first the 10 days of paid sick leave, and then if it continues that they are caring for their child, they can apply for the 10 weeks of paid emergency family medical and leave. So there's a lot of support to the employee to be able to take this, and this applies for everybody that would be on the call today likely. Now there is a cap of salary, and you can find out a little more information, but I'll have that in the presentation that I'll be sharing with you later on. Now they can also use any other leave that is extended to them through your company. So these are just things that really help the employees stay employed during this altered sense of workplace that we're at. All of this can be found on the Department of Labor poster, and that's a poster that should be provided, have been provided, and if not, Brooke might be able to make that available to all of you that are on the call, at least the link. But that would be helpful for you to have, and also for your employees to better understand what their rights are under the FFCRA. Now, the next thing I'd like to talk about is the CARES Act. This is the Coronavirus Aid, Relief, and Economic Security Act. Another set of acronyms that have been added to our vernacular over the last 30 days. It helps keep workers paid and employed, and it helps with economic stabilization. So the CARE Act amends the Small Business Act, and it provides loans to small business. Hopefully, you have already been out to see your banker to apply for this particular loan, to see at least if you qualify. And it would make sense if you haven't, please go down and talk to your banker, because this is an employer-centric, there's parts that are employer, but the loan is an employer-centric addition for your business to stay afloat during the next untold months of this altered workspace. The period began on February 15th. It goes till the end of June. And this allows for 100% federally backed loans to eligible employers. Now, part of this plan also allows for employees to receive an extra $600 a week if they have already applied for unemployment. And your workers who are not working full-time but were always scheduled to, but you cut their hours, they can apply for those cut hours through unemployment. And if they receive that, they will also receive $600 a week as a federal stimulus. They don't have to do anything for that. They just are applying and receiving unemployment, and they'll receive another $600 a week. And that's a fantastic program to help them along during, again, this altered workplace. So we'd encourage you to let your employees know if you even have reduced their hours, but not cut them altogether. And of course, if they've been cut, they would be receiving that likely. There's a lot of peculiarities on receiving unemployment, which I don't have time to talk about today, but if they are receiving unemployment, they're going to receive the $600 as well. And that's already money that is being given to individuals according to people I know that are on unemployment. Now, just to recoup here what I've said, the paid sick leave and the family medical leave, your employees must still be employed. And so this is for unemployment situations that they might receive that $600 or altered work time. So, you know, if they used to work 40 and you cut them down to 20, they may be eligible as well for that $600. There is also the employee retention credit. And if you're not familiar with this, please take this acronym down, the ECR, and make sure that you contact your accountant or CPA to discuss this employee retention tax credit. It's also part of the CARES program. It's a tax credit available to eligible employers for wages paid after March 12th and before January 1st, 2021. So this is extended, unlike the $600 extra payment. And this is regardless of employer size. And so you are eligible if your gross receipts in your business have dropped down under 50% from first quarter 2019. That's their benchmark for this employee retention credit. And so you would be getting a credit of about 50% on your wages, including any medical premiums that you're paying for your existing employees. So this is absolutely something you'd want to talk to, again, your accountant or your payroll provider to get a little more information on this that will allow you to better understand it. And lastly, what I want to talk about, because I think we've kind of not reached any apex as they, you know, we're again more, not so much an acronym, but we're learning all of these new terms that are out there that are now ending up on stories and songs and all of that have to do with COVID-19. So when I say apex, I don't think we're over the top yet, but I think we're going to be there. And what's going to be important for you as an employer is to get yourself ready for return to work, because this is not going to last forever. We certainly need a crystal ball to know when it's going to be and what it's going to look like. But I want to cover a couple of items here that I think are going to be very important as you consider returning to the regular workplace, or what I'm considering the new norm, because clearly it will never look like it did on January 1st. Things will have changed for the long run, for sure. So Governor Newsom yesterday shared that likely the stay-at-home restriction will continue until May 1st. And other things like big events or events as a whole might even be restricted through the summer. So we don't know exactly, but we have to prepare that we might be able to open, but in an altered state. Beyond this, Governor Newsom will assess making sure that our state infrastructure can handle additional outbreaks, because once we're returning, we will have more people exposed to the virus, because the virus will never actually go away. It will be lingering. And so we have to, as employers, and if we're going to reopen and bring our employees back and bring customers back onto our property, we have to be thinking about a couple of things. But as Bob Dylan famously said, times they are changing. They're just not going backwards. So what is going to be important for you is to establish healthy work protocols and processes. We have those generally in our safety manuals that all of us have. If we have an IIPP, we talk about safety, but this is not what I'm talking about. This is something completely different. And so we have some things that we have to consider as we're bringing people back into the workplace. It's the safety piece of it. Then the tension between getting up and running as soon as possible and versus taking chances with the health of employees and your customers is going to be quite a quandary for you. Employers do have a duty under OSHA, which is the Occupational Safety and Health Act, to make sure that they provide a safe workplace. And you're probably wondering, how do we do that in the age of COVID-19? So you're probably going to be doing things like providing PPE, personal protective equipment like masks, gloves, and cleaning supplies. You'll probably be updating your protocols for cleaning and implementing regular housekeeping that you've never done before. You're going to be likely putting social distances guidelines in place. and disinfection guidelines in place. Maybe even doing things you've never done before, like putting kick plates on the doors so people don't have to use the doorknobs. You know, there's just going to be a lot of reconsideration on the way our business looks, and you'll have to be putting these in place so you're able to keep both employees and customers safe in the workplace. Really what you're trying to do is make sure there's no unnecessary risk arising from the virus, and that you can't possibly mitigate. You're going to have to look at all of those things that you have to be able to do. So your hygiene practices will have to be elevated, and especially for those in the hospitality industry. Employers will need to be vigilant before returning to work and making sure measures are in place for the safety of their employees. And I mentioned masks. Even Governor Newsom mentioned if we begin back into the workplace, we will likely be wearing masks, both employees and the customers. And there's a lot of discussion about what masks mean to the healthy versus unhealthy. Probably the patent answer is going to be, for a while, we'll all be wearing masks. And then you'll have to have a protocol. What happens if you have an employee or a customer who refuses to wear that? You see, there's a lot of this healthy workplace protocol you're going to need to consider, establish, and implement before you open your doors, you know, fully to both employees and customers. Another consideration is when you start to bring back in your employees, what do you do about those that really cannot return? And that's because they have child care issues. Now, summer's coming up and they would have had those child care issues anyway, but what if their normal child care provider during the summer is closed? Then they're not reopening. You see, there's a lot of things to consider with bringing somebody back in, that is not just about bringing them back in, it's about their situation at home as well. So something else to consider. Another consideration is, again, you know, what protective equipment are you going to be offering to them? There are some companies that are considering putting in place temperature screening. The World Health Organization and the CDC agree that this is something that we can request from both employees and customers, but you'll have to have protocol in place. You'll have to have training for those that are conducting that temperature screening, and really how you even monitor that and record those things. So we just want to be thinking about all of these new considerations we've really never considered before we get back into the workplace as a whole. Companies will need to have these strong protocols to stave off any ADA issues. We don't even know what that looks like, but I think the CDC has already some temperature screening guidelines in place. I'm certain we're going to learn more and more as the days move forward here. Checks could curtail COVID in your workplace, those temperature checks. So if you've not considered it, just keep it as an option to keep both your employees and your customers safe in your workplace. So again, we're going to want to look at all of these protocols before you begin and you know, we're all learning at the same time. Again, I do applaud you that you're trying to learn more and more through sessions like today, and I'll get the information to Brooke. She can send that out hopefully today or tomorrow, so you can look back and recall. And then if you have any questions, I'll put my email on one of those screens, and that way you'll have it and you can email me with the specifics that are related to your particular industry. So thank you so much for the time.
Okay, thank you. We're going to go ahead and introduce Jenny Shin. Jenny, take it away.
Thank you, Brooke. Thank you, Jan. That was really great. And you handled your technology issue with grace and professionalism. We are all experiencing that. I feel like I have a new video conference issue every day. So well done. And I know that Brooke will get everybody that information. So yes, welcome everybody. I'm pleased to be here. I have actually been elevated to partner at Rosenstein and Associates. That was a recent change, so now I'm a partner there. I have been a practicing attorney since 2000, and I started my career specializing in labor and employment law. I worked for a boutique firm up in San Francisco for a few years back in the early 2000s. And so I've advised private sector employers, public sector employers, higher education employers for 20 years now. Hard to believe it's gone by really fast. But Rosenstein Associates, for those of you who know that Penny Dome building that's right next to Temecula City Hall, that is Rosenstein and Associates. My principal, Robert Rosenstein, has been practicing for 40 years, and we do all types of business law. And so any types of business needs you can call. But yes, I'm an attorney. Yes, this is a legal presentation, but this is not legal advice. I, of course, have to give a disclaimer, especially with this these fluid circumstances. This litigation was rolled out very quickly. There's been a lot of questions and a lot of interpretations of what's going on. We have some basics we can talk about, but for your specific issues, you really should contact your legal counsel to ask very specific questions. And I've been monitoring kind of the chat questions or the Q&A, and so I will definitely answer the ones that have been posted. If you have more, make sure you get them up there. Number one, wanted to talk about for the FFCRA, everyone's asking about seeking the exclusion for small businesses. And we have not, okay, the Department of Labor, the Secretary of Labor was tasked with issuing guidance on that. And the only thing that they've basically issued is if you're seeking the exclusion for small businesses, and a small business is defined as 50 or fewer employees, then retain your documentation. By now you should, we all have had to do that analysis. How long can we stay open, right? Or you're looking for that emergency, those emergency loans. So right now you have your finances nicely packaged. Make sure you keep those nicely packaged because that's your best documentation. If you are claiming an exemption from this legislation, you basically have to show that it would cause catastrophic economic damage to your business. And that's a reality. The first 2 weeks, we've got plenty of phone calls of people saying, I can pay the paid sick leave and then go out of business, or I cannot and stay open. What do I do? And the government wants you to stay open. Just make sure that you have your documentation in order to show that why complying with that would really cause you catastrophic economic hardship. Okay, that's the first, I wanted to get that out there. Jan mentioned asking for doctor's notes right now, and the conservative advice and recommendation that we are giving our clients is not to ask for a specific doctor's note, because right now it might not be possible for somebody to access that information. You know, we want to preserve our medical resources for, you know, any surge that's going to happen, or we just want to make sure that we're using our resources as wisely as possible. So we've actually just recommended documentation. You know, when that employee tells you they need the leave and what's that reasoning behind it, you just document the name of their healthcare provider who told them that they need to quarantine, and that's sufficient for now. So that's our general recommendation there. And then just to echo Jan's recommendation for, go to the Department of Labor website. They have a special website. It's dol.gov/coronavirus. They have a lot of very user-friendly articles, Q&As, all kinds of things that are both for employers and employees. They have a portal for employees, portal for employers, and I found it's very reader-friendly, very, very user-friendly. So that's a great place to follow up for more information on what we've covered today. A question came up in the Q&A about for under the CARES Act, the unemployment insurance, and whether that $600 bonus, if you will, is available for part-time employees. And yes, part-time workers are getting that bonus as well. The way the law was drafted was that basically it is for those workers who receive any portion of their state's unemployment insurance compensation. So it does cover part-time employees, and I've confirmed that they have been getting that. I know for sure part-time employers or employees whose hours were reduced qualified for that. So that's good news. For those who have cut hours and not elected to completely lay off their workforce, that they are eligible for that. Talking about safety. So as Jen said very wisely, and I kind of think of it as phase 2. Right now we're all in phase 1. We don't even know when that's going to end or what it's going to look like. But this mythical phase 2, right? Coming back, opening our doors, getting back to business, what that's going to look like. And, you want to do best practices, obviously, for the health of your employees, for the health of your customers, for the health of your business, but you also for your legal health. We're already hearing, that there's lots of attorneys that are just lining up, just waiting to file claims as a result of coronavirus and COVID-19. Your best kind of prescription is to follow your health, follow the health officials' requirements. Whatever your local health officials are saying to do, you follow that, you document that you have followed that, and that's really kind of your best way to protect your employees, to protect your customers, and to protect your legal health. Right now, OSHA has also been issuing new posters, kind of talking about how best practices for coronavirus. So there was one that was released on April 6th. You can access that on that dol.gov website. So you want to make sure that you communicate that. And if you have remote employees, email it to them, post it in your workplace, get that ready to go. And they're very common sense things that we've all been hearing about. If you're sick, stay home, how to protect yourself, how to clean. So follow those guidelines. Really, that is the best advice I can give. If you get nothing out of this presentation today, except for follow your health official requirements, follow your health officials' requirements. That's going to be our best protection. Now, there are some other things that I wanted to talk about. If you have employees that are able to work remotely in any capacity, have them work remotely. That's really your best thing, because then you're not talking about paid sick leave or paid family medical leave. We all have to be as flexible as we can right now. And so, non-essential employees who can work remotely should be working remotely. It's my overarching advice. We talked about, Jan did a great job talking about the sick pay, the paid sick leave, and then that Family Medical Leave Act, expanded FMLA leave. And she did a great job explaining, yes, those 6 reasons you can get that paid sick leave. And then it's really just one reason that you can get the expanded FMLA. And I think timeline-wise, we're about getting to where we're going to start to see that those FMLA claims come in. If you have, your workers working remotely, or if you're an essential business and you're open right now. So the most important advice I can give you here, again, it's employees that have been employed for at least 30 days. They are eligible for a maximum of 12 weeks. And that actually, those first 2 weeks, so the first 10 working days, would be the paid sick leave. So they don't get 2 weeks paid sick and then 12 more weeks of FMLA. It's 12 weeks total, not 14 weeks. So that's something that is kind of confusing. Even without all this emergency legislation, FMLA is a little confusing. So the leave for your teleworking employees, it can be taken intermittently. So they can take it a couple hours every day. So that's something that you have to work through. And then there are caps that apply on the compensation that they're eligible for. So, and it depends on how long they were, what hours they were working. It depends on the reason for the leave and things like that. So there are caps here, and it is complicated. I'm not gonna say it's not, but I think enough of us now have been working with it long enough where we could talk you through it pretty quickly. So again, I encourage you, if for your specific situation, just give us a call and we can give you more specific advice on that. Trying to see, we got new questions. The PPP or the EIDL loans, do we personally know of anyone who's actually received the money? No, I do not. We have lots of clients who are in the process, and that is a process. I have one client who is supposed to be getting her approval today or tomorrow, and so she would be my first. And she started the process the very first day that you could. So for those who are going through that, and just stick with it. I've heard that they're predicting that it's going to run out of money this week, but I imagine they're going to allocate the additional $250 billion to that fund. So don't give up. And unfortunately, do the best you can with all those documentation requirements. Unfortunately, you know, we had the Terrorist Act that has required banks to ask for all of this documentation that would normally take you 6 weeks to pull together. And so I feel for all of you that are going through that process, because it's not easy. Let's see, we talked about part-time. Independent contractors qualifying for employment benefits, they log in and they apply just like anyone else does right now. So have your independent contractors go ahead and just log in. They're treated just like everyone else for this purpose, for the emergency legislation. Now, if you have independent contractors as part of your workforce, just as an aside, with AB 5 in place and the law that's been changed as a result of AB 5, you need to really do kind of an audit of your independent contractors just to make sure that they truly are independent contractors. Pretty much if they're doing the same type of work that is the reason your business is open, they should be employees. That's my general umbrella statement. But I saw independent contractors and it raised that red flag for me. 2 weeks sick leave. All employees are entitled to the 2 weeks paid sick, even if they started 1 day before this whole thing happened. That there's not a 30-day requirement for the paid sick leave portion of the FFCRA. The Expanded Family Medical Leave Act has the 30-day requirement. Have I answered everybody? Make sure I get everybody. Okay, so small businesses. So now, okay, this is a good question. Here's the question. Diana asks, my concern is what is the incentive for employees to return to work when they're making more on unemployment with the $600, right? Some people, and I know personal people in my family who are doing pretty well with unemployment, but the saving grace is that it's temporary. It is only through July 31st. So after that, I guess then they'll have incentive to come back. And frankly, with the most recent projections that we're hearing from Governor Newsom's office, you know, he's saying things aren't even really going to start to be open in any meaningful way until August. So we'll just have to see. But this does have an expiration date on it as of right now, so that should be their incentive. And as a practical matter, nobody can afford to be in this kind of scenario for more than a few months. The country can't afford it, business can't afford it, nobody can afford it. So it will end and it will get back to some semblance of normalcy. But I love Jan's presentation where she's saying things will be different. And so stay tuned and keep, your HR resources close because the advice is changing constantly. Access that dol.gov website. Check out RIV, RIVCOPH, their website, Riverside County Public Health, because they are constantly giving us new guidelines that are frankly more stringent than the feds. So make sure that you're just checking your local resources every couple of days. I check it every day, first thing I do in the morning now. But at least every couple of days because it is changing so quickly. Those are my overviews. Again, with specifics, I really can't get too specific. What I would say for your telecommuting employees, for those of you who have teleworkers, and I can't tell how many of you do, just your best practices right now, if you have your non-exempt employees teleworking, is just make sure you've clearly communicated their expected work hours. You've clearly communicated they are expected to take all of their meal periods and their breaks, and that they are, clocking in or whatever your system is for them to do that they are still making sure that they are taking their breaks. Because for me, wage and hour claims had already kind of entered the valley here about 9 months ago. We've got a few big firms that have started targeting local businesses about unpaid, or meal and rest breaks that people aren't taking. And because now they can get attorney's fees, they can get waiting time penalties. It's just really lucrative right now for attorneys to do that kind of lawsuit or claim. So when this all came down, the first thing I thought was, oh, get those employers reminding their non-exempts, take your breaks. Here's your hours. I don't want you looking at your email after hours. You know, the thing about teleworking, psychologically, you're here and it's here. And it's so easy to just jump on when you should have been clocked out. So just really make sure and reiterate those policies.
Jenny, if I could just add a note to that discussion, I'm so glad you brought that up, because I do know I have a lot of clients that have used that opportunity to have employees work from home. And my suggestion is that you have a telecommute agreement or a telework agreement, because it would spell out all of the expectations that the company has of the company and the employee during that time of telecommute. So the things that Jenny has mentioned in terms of wage and hour, a good strong telecommute agreement would have all of that. So if you do have people and you don't have that agreement in place, you've got resources with your HR groups or your attorneys to make sure that you have that in place.
Very good. I second that. There was a question that came up. If an employee was laid off in March, can they qualify for the 10-day sick pay? No, they do not. It's only for people who are employees as of April 1st. I heard the employee must request the paid sick leave. Do I have to provide this information? So you are required to post. There is a poster that's issued by the Department of Labor, and technically it should have been posted, quote unquote posted, March 25th. How you post it to your remote workforce is you email it or text it, or however it is the most common way you communicate with them as far as your written, communication right now electronically, and then post it in your workforce or in your workplace. But it does talk about what's available, and that's how you take care of that requirement. What about when they are recalled? Let's see, is this a follow-up? So I think this must be a follow-up. If an employee was laid off in March, but then recalled now, would they be eligible? Yes, they would be. It's the effective date for sick pay is through December 31st, 2020. So when they're recalled, they would be eligible for that. And again, I mean, the point of all of this, we have to kind of keep it in mind and not drill down too much into the weeds. It's to keep people from spreading the virus. If you're sick, they want you to not go in contact with other people. So this was the government's way of being able to make sure people could afford to do that. Because realistically, for a lot of people, they can't afford to just take unpaid time. And so basically that was the whole point of this. So yes, as long as this legislation is effective through 12/31 for the sick paid portion, then when you recall them, they'd be eligible for that. But again, I know it doesn't help with cash flow, because as employers, you guys are the ones that are writing those checks, but you do get that tax credit that it is quarterly. It's against the Social Security portion of your payroll taxes. So, you will be fully made whole. So if what you paid out was more than that amount, you are supposed to be getting checks from the federal government for the difference. So I know, again, it doesn't help you with cash flow, and hopefully those EIPL loans, they start actually hitting, and they should. But again, fluid situation, we're all trying to be flexible and patient, and we are all going through this as business owners, as parents, as all kinds of people right now. So take heart, you guys are doing great, and I'm available to answer any other questions. Let's see. All right, if Jan wants to follow up with anything.
No, I did want to follow up because we do have probably people that are on the call that are already subject to the FMLA leaves. And you may have a question, what if somebody has already taken a portion of FMLA already? So if you've had that case, if my understanding, and Jenny, you can correct me if I don't have the right understanding in this, is that is already time used towards or should be allocated towards the 10 weeks of the emergent or expanded Family Medical Leave Act. So if you've already had somebody taking some time, that would reduce this extended. Is that what you understand as well, Jenny?
Let me see. I know that initially that was kind of the most common recommendation I was getting out of law firms, but I believe that the Secretary of Labor actually issued additional guidance on that.
Would you be able to provide just to Brooke, and maybe Brooke can distribute that to the participants? Because again, we do have some people on the call that may have be a bigger organization and have that subject to the Family Medical Leave Act already in the first couple months of this year. And if that's a question you needed answered, at least they'd have some material for that.
I will do so. I'll follow up with Brooke. I'm trying to see right now. Maybe I might be able to find it.
Okay.
While you're looking for that, there was another question that came up. Can you get benefits if you quit in October and can't find a job now?
Are you talking about unemployment benefits?
It looks like that.
They would be able to apply for unemployment, and they would have to just indicate who their last employer was and the last day that they worked. It's a good question if they would be able to be subject to that extra $600 stimulus, and I don't have the answer for that. But it does appear if you are receiving any amount, even $1 or more of unemployment weekly benefit, you are entitled to the $600, I call it the stimulus money as well. They should still be applying.
And also, it's my understanding that another part of the expanded unemployment insurance provision is for those who are already on unemployment and they were looking at their benefits expiring, that they've tacked on an extra 13 weeks to that. So that would apply to somebody who'd been collecting on unemployment last year. So I know that part of it, but I'm not sure about the $600 extra. I don't know.
We're all learning, aren't we, Jenny?
We are. Exactly. And
all of us, every one of you business owners is learning how to maintain business in this very interesting environment. And as I mentioned, as everyone does return to work, it will not look like the day that you left it. And if you're currently in business, you know that because you're not doing business exactly the way you were at the beginning of the year. We're all kind of in this together, and it's great that you are trying to maintain business, and we hope this will be over soon.
Well, thank you both so much. Do any of you have any last words you'd like to contribute before we end?
And then I do actually have a question for that FMLA question.
Okay.
If it's not additional, so you're right, Jen, if they have already used up their 12 weeks, then they would not be eligible for the expanded family medical leave. Depending on what they have used, it's that maximum of 12 weeks.
Thank you for finding that. I appreciate it.
Okay. Well, we're going to go ahead and probably wrap this up. Thank you both, Jan and Jenny, so much for presenting today. We have recorded this presentation, so we will send a link to everyone too so they can listen to it.
Thank you.
Thank you.
Thank you both very much. Okay. Go ahead and end the call. Thank you very much.